question, once a judge decides to apply foreign law, how does the judge determine the content of that law and the meaning of that law? And in some cases, this is relatively straightforward. A California judge trying to determine Pennsylvania law will have resources readily available. The parties have those resources readily available. However, if the foreign law is the law of a foreign country, the process can become somewhat more complicated. And even with a wonderful treatise on foreign law, that's not necessarily going to be sufficient to allow the judge and the parties to develop a correct understanding of that law. The context of a legal system is very important and should be considered. There are issues of translation, of course, that can come up. The second restatement didn't provide guidance on how judges and parties should go about determining the content and meaning of foreign law. It simply provided a choice of law rule that said those issues should be decided in accordance with the law of the forum state. What we're trying to do in the third restatement is to actually provide some concrete guidance for judges and litigants, and there seems to have been a thirst for this guidance. There's a federal rule and roughly analogous state rules that provide some guidance, but is silent on many issues of importance to judges and litigants. So what we're hoping to do is to fill this gap, to provide concrete step-by-step guidance for judges and litigants that hopefully will help them when our choice of law rules indicate that foreign law should be applied.